So my name is Krista Kemp. I'm the Director of Donor Relations with the Vermont Land Trust. Part of my job is helping people with their legacy planning and conserving land for the future of Vermont. And so I came to the Vermont Land Trust about 10 years ago from the finance industry. And about 4 years ago, with careful observation, I realized that about 80% of the bequests we were receiving were coming from women. And I knew from my experience in the finance industry that there wasn't explicit education for women around finance and about how to care for their funds, how to steward them after their spouses passed away, when all sorts of questions came up that weren't being answered. And slowly that industry is changing. And I thought, well, I have the opportunity to make those changes too, here with the organization I work for. So with that, we decided to run 3 focus groups with between 10 and 12 women per group. And we found that what women wanted most was a collegial, supportive, encouraging environment where they got expert advice for free. So that's what we're doing for you today. And I would like to tremendously thank our expert panel of Livia DeMarchis from Gravel and Shea, Jeanne Blackmore from Gravel and Shea, and the Honorable Susan Fowler, a retired probate judge who now works for the Trust Company of Vermont. We have found that these workshops have been incredibly useful for people, and also that people support each other. Women are supporting each other within the workshop. So please do feel free to ask questions. Those really drive deeper learning in the planning that you are hoping to do, and also the education that you may pass along to members of your family or friends. I see a couple of women together watching, and I'm so glad that there are 2 of you on the same Zoom call. So thank you. I don't know if it's a friend or a sister or how you guys are related, but I'm really psyched to see you both here. That makes me happy. Oh, you're married. Yay. Okay. Terrific. Terrific. So one of the things that I learned in a little bit of research, and I'm astonished by this, but by 2030, women will hold roughly $30 trillion of wealth. And so what that says to me is there is a lot of power within our gender to change the world and to leave legacies or to build a future that we want to see happen. I also know from some of my research that 68% of Americans do not have a will right now. And what that means is your assets may end up in directions or doing things that you don't really wish they were. And that's what we're here today for. So without further ado, I would like to kick off our program, and I'll start with the very first question of why do I need a will? Why do I even need a will? What if I don't do anything? And I'll leave it up to Livia. Let's kick it off with you.
All right, sounds good. Yeah, good morning, everybody. It's nice to be here with you. My name is Livia DeMarchis. I'm a partner at Gravel and Shea, as Krista mentioned. So yes, why do I need a will? So the simple answer is that a will is a document that allows you to describe who should receive your assets when you die and how they should receive them and when they should receive them. And it also is going to allow you to name an executor, who's the person who shepherds assets through the probate court administration process and collects assets and protects them and makes sure that they get to the beneficiaries that you've named in the way that you've described. And finally, a will is important because for any folks who have minor kiddos, it allows you to name a guardian and successor guardian for those children. Now, a will specifically is a document that's administered through the probate court process. So it really controls any assets that are titled in your individual name when you die. And just to note, and Jeanne's going to talk about trusts in a little bit more detail in a minute, but when we do estate plans, we typically use revocable trusts as will substitutes because it's an effective way to pass assets outside the probate court process. And the court process can sometimes be more expensive and more time consuming than having a trust, which allows you to kind of set up a parallel process to the probate court process.
Good to have had the job that everyone wants to avoid ever having anything to do with you.
Sorry. Sorry. Didn't mean to insult her.
I'm not bitter anymore. I've learned.
Good.
So is there a specific time when you should start thinking about putting together a will? Like how old, is there an age? Is there an event? When should people start thinking about this?
Yeah, no, that's a great question. I mean, I guess I would say as soon as you have or are expecting any kids, that's definitely a time when you want to have a will put in place. But then otherwise, if you have any assets that are titled in your individual name and you want to make sure, that they pass to the intended beneficiaries in the manner that you intend, you're going to want to think about creating a will.
Jeanne, do you think that you're ever really done with your will? Does it stop? Are you done?
Are you done? No, you're never done. Well, that's hard to say. And it was really hard doing estate planning for people in the pandemic because people were thinking about a lot of things when they were either putting in place their first estate plan or updating, because you can only plan your estate for what you know is right in front of you. So whatever you want to have happen today is what your plan should be. You can't plan for some event 10 years down the road. So we do tell people to revisit their estate plans when there's been a change in circumstance or a change in the law, a change in the way you want your assets to pass. So no, you're really never done. It's just like anything else in life. You think you've achieved some great goal, but then there's just something else to do.
I guess the only time
like the dishes or something.
Yeah. Yeah. I think really the time you're only really done is when you're dead.
Even then, people can do their estate plans so they're just sticking their hand out from beyond the grave, but that's a limited.
That's the advanced class.
That's the advanced.
That's the next session. All right. So the next question I have is, you touched on this a little bit, Livia, with the very first one, but what is a trust and how do I know if I need one? Sue, do you want to?
Well, we can let Livia answer that. I mean, the trust is really the way to take your assets and have them distributed in the manner in which you want them distributed, or to carry on for future generations without going through probate. So when you die, you set up the trust to survive your death. So there'll be certain provisions that say, during my lifetime, I want these things to happen. I'm going to make all the decisions myself unless I'm incapacitated. And when I die, then this person takes over as trustee, or this company takes over as trustee, and they are to distribute assets in this certain way, and the trust will terminate on this date. And you avoid going through the probate process and having the court involved in the mechanism of how your estate is distributed. And with the probate process, unless you set up a trust through your will, which, well, we won't even go there right now, but unless you set up a trust in your will, everything's going to be distributed at the time of your death, as soon as the bills are paid. And the trust is a way to keep things going. You don't want your kids necessarily to get a bunch of money when they're 20 if you should die in a fiery crash. So you want that to last and distribute maybe out to them when they're 30 or 40 or 50. And that's one of the things that the trust can do. Jeanne and Livia can probably expand on that.
There's just a really good question somebody asked about if there is a trust, is there no executor? And just to clarify this whole structure, which is very confusing and Zoom makes it worse, but a trust is basically a private will. It's a way to pass your assets on your death without having the probate court involved. And whenever the court's involved in the transfer of assets from a dead person to the intended recipient, it's a very formal legal process. And if you can do that with a trust, then it's a private arrangement between you as the dead person and the person you picked as your trustee. Whenever we do an estate plan using a trust, we always have a will. And the reason why we have a will is because the idea when you do a trust is while you're alive, you title all your assets in your trust so that when you die and your trust becomes irrevocable, the person who succeeds you is automatically there with all the assets in hand. But if you forget to put something in your trust, like a fancy piece of real estate in Hawaii or a little bank account in Delaware, then your will designates your trust as a sole beneficiary, and it takes that little asset, and there'll be a little tiny probate that just deals with that and pops it into your trust. So the answer to that question, which is longer than probably the person who typed it thought it would be, is when you have a trust, you still have an executor, but the goal is to never, ever make that executor do his or her job.
You say, just to clarify, Jeanne, when you say put it into the trust, people sometimes don't know what that means. It really means you're just changing the title. So instead of me owning my car individually, my trust owns it. So the owner would say trust estate of Susan Fowler instead of Susan Fowler personally. So sometimes people just forget in the haste of buying things or moving things around, they forget to change the title from themselves personally to their trust, and that puts it into probate.
Exactly. Yeah. So the goal while you're alive is to title everything in the name of your trust or in such a way that it automatically passes outside of probate. So by beneficiary designation, for example, for retirement accounts, or by joint ownership. And so the idea while you're alive is that you're going to be typically trustee of your own trust. You're the donor of your trust. You've created it. And you're also the beneficiary. So all of the trust assets are held by you as trustee and managed for your benefit while you're alive. And then when you die, the trust document names a successor trustee, who's the person you are entrusting to manage those assets for the benefit of your beneficiaries, who are also named in the trust. And as Judge Fowler said earlier, the trust dictates how long those assets stay in the management of the trustee for the benefit of the beneficiaries. And you can name different ages of distribution, different kind of triggers for distribution, depending on your family and your circumstances.
One question from a participant is, they own a few shares in their local co-op grocery store. Do they need to change them and put them into the trust, or do they just exist as they are?
That's a good question. Theoretically, yes, everything you own should be in your trust, especially if your kids are so excited to inherit those City Market shares. I wouldn't stress overly about, I like City Market. I wouldn't stress overly about it, just because it's unlikely that you'll own those at your death. And I'm not sure that they actually have any value. But theoretically, yes, everything you own. There are certain things that we can put into trust with, like a blanket document, like, for example, personal property, like my Bernie painting and my Obama painting. I can put into my trust with a blanket bill of sale that says all my paintings and artwork and furniture and earrings, all of those are in my trust. But yes, the idea is to get the whole kit and caboodle in there. It's like a suitcase that you're packing for the ultimate trip. So you can make a trust, which is your suitcase, and just throw your clothes on the bed, or you can actually put your clothes in the suitcase and close it. And that's the goal. Put the clothes in the suitcase and close it.
Oh, somebody's muted. Krista, I can't hear it.
Sorry. So I think the next step then is for people, they're wondering, how do I find an attorney? How do I figure this out? How do I get started?
Well, it's like in everything else, there's good and there's bad. And it's important to get a good attorney so you don't end up spending $1 zillion and not getting a good product, just the same as in everything else you do in your life. You could start anywhere by calling Jeanne and Livia, and they can refer you, or you can call me and we can refer you to someone who's capable in your area. We can find them, and it's not necessarily out of state, although I bet Jeanne and Livia have a lot of people out of state. I'm sure they do, because I've used them before to find trust attorneys in different parts of the country. We have clients who are needing one. The other thing you can do is to call the probate court in your county and ask them for names. And ethically, the court, at least in Vermont, cannot give you a particular name, but they can give you a short list of names. And the court is dealing with these lawyers all the time, and the ones that charge $1 zillion and don't do a good job, they're not going to refer you to them. So you're in pretty safe hands to call the court and say, can you please give me a short list of attorneys? But it's also good to call someone that you know or call one of us, but I wouldn't blindly just call somebody personally, just because the result isn't always good. And with a really good lawyer, and I'm not even saying it to butter them up, although I like to butter them up, really are two of the best in Vermont. And you know, when you get that kind of competence, things just go smoothly, and it's fast and it's efficient, and it's not exorbitantly expensive because they know what they're doing and they're not billing you while they look it up and learn it on the side.
Could you give us, I know, like when you interview with someone or you're having a meeting, you get sort of an intuitive or initial vibe about working with that person. But could you give us some red flags that we might watch out for if we're in a meeting, a get to know you meeting, and the attorney is saying something or suggesting something? What should we be looking out for?
My biggest rule of thumb is if somebody can't explain something to you in a way you can understand, they don't know what they're talking about. Of course, now I hope that everybody understood everything Livy and I said already. But I think that's really important. These are complicated issues. And if you know what you're talking about, you should be able to make it understood. And you should take the time if somebody doesn't understand. So that's the biggest thing for me. I'm also always nervous about lawyers who charge flat fees for estate plans because for two reasons. First of all, I can do an estate plan for someone who's super independent and they've done a ton of research and they make my job really easy and we're done in 2 hours. And that's going to cost a lot less, obviously, than somebody who has a ton of questions. They want hand holding the whole way, which is fine, but that takes more of my time. So if somebody just says to you, it's 10 grand, that just seems off to me. Also, I think a lawyer should not consider you one and done. Right? You should have a relationship with this person that should be continuous. And so this concept that it's just give me your money, here are your documents, and I don't care if I ever see you again is, I don't think, the greatest way to have a relationship with an estate planner. There was somebody who said before that their accountant recommended their estate planner and they work together. And that happens all the time and is another way to find a great estate planner, because accountants and estate planners should work hand in hand, especially for people who have complicated estates.
I'm just going to.
That's exactly right. Yeah. Or financial advisor.
One thing that I used to see in court and I see here now at the Trust Company of Vermont, because we get trust from all over the place all the time. I am always concerned when I see a document that is 60 pages long, because so much of that is often just boilerplate and gobbledygook that you just got to wade through it. It's not dispositive. It doesn't really say, as Jeanne was talking about before, it doesn't really give you the nuts and bolts of what you want. It's so generalized to try to fit everybody that you're just plugging your name in. So it should be a document that is of a length where you can read it in a day and understand it. You know, when they give you a draft that is 50 and 60 pages long and most of it is words you have never seen before, I would want a second opinion on that.
Mm-hmm. I think that's an excellent point. And I guess maybe one question that kind of dovetails with that you could ask is whether the attorney uses software to generate trust, because it's usually, I think, attorneys who use this document generation software and don't actually draft their own documents that end up with these, 60, 70 page long documents. Whereas, really, if you're drafting it from scratch yourself, it shouldn't be more than like 15 pages. So.
Right. Yeah, that's, and those are the good ones that you can make sense of. But when they're super, super long, I would be worried that they weren't particularly tuned to your individual situation.
Mm-hmm. Great. Thank you very much for those answers. I'm going to ask a question now that ties into another question that was asked. Jeanne, this is one of my favorite illustrations that you did. How do I maximize my to heirs, organizations, friends, and minimize what goes to the government?
Oh, I know what you're getting at. Yeah, so
first you have to take down your Bernie sign.
I know, exactly. So and this analysis is like a pie. So to back up a little bit, Chris is talking about estate tax. And for some of you who have lots of net assets, and I hope all of you have lots of assets, if you have more than a certain amount that you're leaving to the next generation, you may be subject to estate tax. And in Vermont, that amount for an individual right now is $5 million. Now, the estate tax is all in flux right now, but I will say, let's say all of you have more than $5 million. All of you has $20 million. When you're giving your assets away, you have a pie, and that pie can go to your heirs and to the government. So there are two pieces, taxes and people. Taxes and beneficiaries. If you want to reduce the amount that goes to the government, you can create two slices of pie on that side, one for the government and one for charity. The amount that goes to people will always be the same, but the amount that goes to the government can be decreased, and you can reallocate some of your tax dollars to charity directly if you don't trust the federal government to do it for you. I usually have like a piece of paper that I can hold in the air, or maybe I'll have an actual pie one day. But that is the concept, that if you don't want to pay estate tax, you can give your money to the Vermont Land Trust, for example, or any other charity.
Or any charity, exactly. Some of the easy ways to do that are as beneficiary designations. And one of the questions someone asked is, if you have no children, may your beneficiaries be organizations rather than humans? And the answer emphatically is yes.
Yes.
The answer is of course. And one important point for everybody who ever uses a lawyer who has any legal affairs in the world at all is that you as a human should control the outcome of all your legal affairs. And that is one way to do that. If you have assets, you get to say where they go when you die, and you get to say the way they go there. So yeah, kids are not relevant to this equation. Have at it and have fun with giving your stuff to people or places that you love.
I think this might be a good time too to talk about land and about gifting land. As Caitlin Cusack mentioned, she is a forester for the Vermont Land Trust, and she works closely with an organization called Women Owned Woodlands. Kate, do you want to say a little about that at this point? Are you there?
Sure, I'm here. Hi, thanks. Yeah, so I guess I would just, for those of you that do own forest land, there is a network. It's a newly established network in Vermont called Women Owning Woodlands, and it's a collaboration between the Vermont Land Trust, Vermont Coverts, Vermont Woodlands Association, UVM Extension, and then the Department of Fish and Wildlife and Department of Forest and Parks. And we're developing a series of workshops and support for women landowners specifically. And so in the follow-up email, we'll send a link to where there's more information on that. But just so you all know that there is a group specifically out there to support women landowners.
And it's taking off in this state, but it's also a national organization. So it's a collective of women across the country. It's a really, really exciting and vibrant group that Caitlin is an integral part of in this state. So really pleased to share that piece of information with you all. Next question, prices. We talked a little bit about what things might cost, but can you give a range of what people could expect for a will or trust or combination thereof? Livia, do you want to launch?
Yeah, speaking of, sure. Yeah, I mean, so as Jeanne mentioned, some attorneys do have flat fees for these services, but I think probably the majority, and I would agree with Jeanne, probably the more sophisticated ones bill by the hour. And so kind of the typical range in my practice in any event for a single individual is anywhere from about maybe $2,000 to $3,000. And then the typical range for a married couple is more like $2,500 to $3,500. And, you know, that can go up or down depending, as Jeanne mentioned, on kind of the amount of specific kind of circumstances, specific questions involved, if we are doing kind of complex retitling of real estate, if there are any business assets involved where we need to pull in a corporate colleague to help work with those assets. But the kind of basic documents, the range for an individual, again, is somewhere in the neighborhood of 2,000 to 3,000, and for a couple, about 2,500 to 3,500.
I know that one of the things you all offered so kindly is a questionnaire that you have people fill out before they come in, which organizes all of their assets and puts things on paper so you have it written down. That seems like an enormous time saver to me, and also a good way for people to get their head around what they have and what they have to look after, or who they want to leave things to. And we will share that with you in the follow-up email as well. I also will throw out there that the Vermont Land Trust has collaborated with an organization called freewill.com. It's an online opportunity to basically do the same style of thing. You can either use it and do your will for free if you have a relatively simple situation, or you can put everything in and then print it off and take it to the attorney that you wish to work with. I personally value having someone to talk to locally, so that's the route that I went, but it is something that's available to make it easier for people to get started. Have you updated your questionnaire at all? Is there anything that we should be aware of around pandemic, around any changes that might have happened in the last year that you all would advise us about?
We're still in recovery, Krista, so we don't know, but
yes.
Don't buy any Bitcoin. Don't put that out there.
Okay.
We probably will at some point. I mean, quite honestly, and all joking aside, there is so much change going on right now, and we're just sort of sitting still and waiting to see where the dust settles. And that is mostly changes in tax laws, federal tax laws. But otherwise, the questionnaire is pretty good. I will say on the doing your own will front, that always makes me nervous because it's even almost impossible to execute a will properly. I will give a horrible example with one of our clients right now who has passed away and did his own will and got so excited about it. He did it like 4 times, marked all the documents up. Some were witnessed, some were not witnessed. One was halfway torn. So we just went to the probate court and said, can you throw all these out? Because we don't even know what the hell is happening. So I guess people, you can do your own will, but I wish you wouldn't.
Yeah, I will concur with that. Or do as Krista perhaps did, which is do it online, but then take it to your lawyer so that you've got the parameters of this is basically what I want. Saves the lawyer time getting the answers to all those questions, but then you can make sure that it's properly executed, which is just means signed and either filed with the court or put somewhere where it can be found again, because so many people die. They do the will and then they don't file it with the court. They don't file it with a lawyer and they die and no one can find it. And so that's another whole process through the court when you can't find the will. So it's important to have a system that is going to work for when you're gone. Where are you going to find that will?
Great. There's a really good question here. What should we consider when trying to select beneficiaries, executors, when our family is out of state, out of the country, and our children are very young?
I would just say one thing from the court's perspective, you would try to appoint someone in the state, because it's very difficult to be the administrator of an estate when you are out of the state, and certainly out of the country. I would never appoint anyone out of the country. It's just the time delay is too much. It's much easier to have someone local. And if you don't have someone local, then find your trustee lawyer and appoint them, because it'll get done and it'll get done quickly and efficiently. And so much delay happens in probate because you cannot, well-intended people who are good and trying their hardest, it's a lot to do. And you don't want to appoint someone who's going to have to travel a long way to get to court. Again, you're trying to avoid court, but in the event that you have to go to court, you want to make it as easy and expeditious as possible.
Is there anyone you shouldn't choose as a beneficiary? I mean, as a executor or a guardian? Or any red flags that?
Family is, I mean, you always immediately go to family, but there's so, I mean, and you have to do it on a case-by-case basis, but don't assume that if your kids don't get along while you're alive, they're going to suddenly get along when you're dead. They don't. And then they go to court and they fight like cats and dogs over everything. So if you've got one of those wonderful, miraculous families or an only child, that's perfect. But if you don't, consider appointing some neutral, capable person to do it, like Jeanne and Lydia.
Yeah, so I'm going to put a pin in that. There have been a couple questions. I'm not a fan of the lawyer who drafts your documents serving as the trustee. I think that makes your client inventory, which is not a good, not that it's a technical legal conflict, but it is, I think, an emotional and a moral one. So we as a policy do not serve as trustee for our clients. For people who have a hard time finding an individual trustee, there are great professional trustees. I'm not going to lie, Trust Company of Vermont's my favorite trust company. I do like other trust companies around the country, but if you want a trust company here, that's a great one. There are lawyers who specialize in being trustees. That, you know, you could have one of those lawyers be your trustee, but have another lawyer drafting your document. And then keep in mind, when you set up your estate plan, that this trustee only comes into place when you die. So you pick a trustee who works for today. In 10 years, there may be a better solution for you.
That attorney might croak. I mean, you guys probably won't ever croak, but most of them do.
I think that this is a great time to talk about how we talk about this topic with our family. How do you bring it up? How do you talk to your children and if you're asking a family member to be a trustee or a guardian or executor? Where do you begin? Sue, go.
All I can think of is the joke with the guy says they're reading his will and he says, and to Bob, whom I promised to remember in my will. Hi there, Bob. Sorry, I digress. I'll let Lydia and Jeanne, because you deal with this all the time with your clients. Oh, they're not there.
Livia, do you want to?
I'm muted here. Sorry. Oh, okay. Yeah, no, I mean, I think obviously it depends on family circumstances and, you know, how old your kids are and that sort of thing. But I think starting off, if you're comfortable, you know, making sure your family kind of has a general idea of your assets and of the kind of inventory that would be involved in administering an estate. And then kind of figuring out who is perhaps the most responsive, not necessarily who is the most financially savvy or, you know, has any legal expertise or anything amongst your family members, but figuring out who you think would be kind of the person who's going to be most equitable and fair and neutral in deciding how distributions are made, and also and have the easiest time coordinating with the advisors that you've worked with in the past. So your attorney and your accountant and your financial advisor, so that they can work with those agents to kind of see your plans through to conclusion. So there's some kind of general thoughts about how to.
I'll toss out there. I worked with a family in Southern Vermont who had 2 daughters, and from a very young age, they shared their will and trust information with their kids. They wanted them to be on board, if you will, with all their decision-making about, they had a farm, how the farm would operate after they were gone, what organizations they supported and why. And I felt like it was a really holistic and very thoughtful opportunity to begin having a financial conversation with their kids to understand what things cost, how to keep them operating. It was a farm that's been in their family for a very, very long time, and they didn't want to pressure either child to remain on the farm, but they wanted to know that the opportunity was there if they chose to. To me, it was like the aha moment of perfect family financial information passing through the generations. And it's been a model for me in working with other families and opening that door. It also, if you remove, it's very hard to sort of separate yourself and step back from the conversation emotionally. But if you can take it as a teaching opportunity and you look at it that way with your siblings or your whoever's going to be involved or whatever education you want to impart, I find those conversations can be really enriching and can come to really nice outcomes.
I want to add just one thing that I see a lot that seems to be very nice thing to do. We often ask people when they name us as a successor trustee. In other words, my husband and I are the survivor of the two of us will be the trustee of our trust until we die. And then Trust Company of Vermont will take over and we'll do that. But they don't want to. Some families don't want to involve their kids in there. They don't want actually the kids even to know how much money they have. That's just a choice, but it's not an uncommon choice. And one thing that they do sometimes, which is nice, is write what we call a letter of intent, which is something that the kids are going to get later on that explains what the parents are thinking and why they're thinking it and why they gave all their money to the land trust instead of to them. It's a nice way to do it without necessarily embroiling your kids in your life early on, because sometimes as parents get older and more vulnerable, not every kid is the kindest about keeping their hands off the money. And the more they know, sometimes, I hate to be negative, but you just see it so much that after a while, I can understand why some parents might say, I've got $10 million, but I'd just as soon not discuss that with the kids today because I want them to finish high school. So that letter of intent is a nice document, and we keep it here and they can update it, and they do, and we always have it, and then we distribute it out when the time comes. That's just another thought.
I would agree with that. There's no one size fits all for this stuff. Everybody's different. Everybody's family culture is different. Sometimes it is easiest to have full disclosure in a family. Other times it's just not workable. Sometimes people are too uncomfortable with it. One thing that I don't like when people are silent is people can be silent because they're afraid to really face what their assets are, what their expenses are, whether they do or don't have enough to make it to the end of their life. And those kinds of things you really need to face head on, right? Sit down. How much do I have? What is my stuff? Where is it? How old am I? How much more do I need? Those are all things that you should really address. But that doesn't mean that you need to tell your family who you're leaving your stuff to. You can, or you can't. So those are two distinctions that I wanted to draw. I remember the first time we did this seminar with Krista, and I was so surprised that so many people didn't know what their assets were. And the idea of listing them on a piece of paper was really overwhelming and seemed impossible for a lot of people. So financial literacy would be step A to getting this whole process started. And Sue can help you with that.
So
I agree with all of that. Sorry, Krista. No, I was just going to add that I think one more point to be aware of is that if it's really clear that your kids have certain expectations about who's going to get what, and that's not the way that your documents are set up, I think, remaining silent is probably not helpful, because that just leads to fighting after your death, would be my observation on that.
Livia, that's exactly the point I was going to make. Sue, do you remember in one of the first ones you talked about how hurt family members can be if they aren't included? about
Yeah.
being excluded. Would you speak to that a
Yeah.
little bit? And
Well, we just used to always, well, I always called them the Smothers Brothers hearings, because I don't know if people remember the Smothers Brothers, but there was one that always said, Mom always liked me best, or Mom always liked you best. I can't remember which one. But we've had an awful lot of hearings in the probate court where parents make a decision, kids don't know about it, no explanation is given as to, this is not a trust, this is not a trust, this is where it's coming through the probate court, and one child is cut out. If you're doing that, you need to put something in the document, whether it's true or not, that says, and I am omitting little Jethro because I love him so much, I want him to make his money on his own. Whatever the reason is, because if you cut out a child or someone who thinks that they're definitely an heir of your estate and they then are not an heir of the estate, that can trigger litigation that is brutal for the family after the fact. So I always used to say to folks, if you're leaving a child out, you can't do that without a reason, whether it's all the reason, you don't have to make public all your reasons, but just put something in there. Because if you just say, and I leave my estate in quarters to these 4 kids, not mentioning the 5th one, that is a guaranteed will contest, where the 5th one says they never would have done that. They just obviously was a mistake. So you need to be clear at some point, whether you do it before death or at death, that you're making a choice intentionally for this reason, because otherwise you're setting your family up for ugly litigation down the road.
Mhm.
I don't know if that answered the question, Kristen.
No, that is what I was, thank you. There's a question in the chat about, can you talk about living trusts versus irrevocable trust? I think of trust for people with more assets than I, but I do have assets. I'm wanting to get rid of assets sooner than my death so they don't get diminished if I need a lot of care early on. I'm not sure which of you might want to answer that.
I can answer that.
Yeah.
So sadly, the topic of Medicaid planning is beyond this seminar, but I think the question relates to giving your assets away so that they can't be considered for purposes of the Medicaid qualification rules for a nursing home, and also the clawback rules. And that is a very, very specialized area. So I think if that person wants to talk to me a little bit about it afterwards, it's not an area that we specialize in, then I could do that afterwards, but that's a super specialized area.
And she also asked Rev versus Irrev trust, if you want to answer that.
Well, I think the point of the question, but I'll answer more, Sue, since you asked me to. I think what that woman was getting at is, if you want to qualify for Medicaid, you give all of your assets away to an irrevocable trust so you don't own them anymore. And then you don't have any assets for Medicaid purposes. So you can qualify to go into a nursing home using long-term care insurance benefits. The drawback to doing that is that you really give all your assets away, and you have to give them away to a person who is not you, who then gets to dole them out to you, which can be an awkward circumstance. And the potential downside further is that most people would not want to go to a facility that accepts Medicaid benefits if they're ever in that position. So that's sort of that very big, quick picture on Medicaid planning. From another perspective, if you're a high net worth individual and you want to do some estate tax planning, then you may want to give a gift for the benefit of your children and their children. And you can do that by making a gift to a trust that's irrevocable. So you give it to sort of this entity, this trust entity. You don't own it anymore. You give it to somebody else to manage for the benefit of your kids, but that results in estate tax benefits.
And just to say, in case we didn't say it at the outset.
I'm just saying, on a really simple level, the revocable trust means you can change it at any time, and the irrevocable trust, it's now just that, irrevocable. You can't come back and say, oh, I changed my mind, I want to take the money back.
Exactly. Yeah.
So I think now there are a couple pieces we haven't covered: health directives, power of attorney. Those are other documents that are really essential in long-term planning. So take it away. Livia, Jeanne.
Yeah.
Sue.
Sure, I'm happy to jump in. Yeah, so that's right. When we do an estate plan, we always recommend at the same time that you put together your trust and your will that you put together a power of attorney, an advance directive. And then if you feel super strongly about certain medical things, you can talk to your physician about forms called DNR and COLST forms. So the power of attorney is a document where you are appointing an agent and oftentimes a successor agent in case the first agent isn't available, who can act on your behalf for financial matters that fall outside of the trust while you're still alive. So that document is most relevant typically for things like your credit card bills and certain retirement accounts, any assets that remain titled in your individual name, not in the name of the trust, that would require some sort of management in the event that you are out of the country or incapacitated. And we often draft those documents in our estate plans to be effective when they're fully signed, as opposed to some people think of a power of attorney kind of becoming effective only upon your later incapacity, but we like to see them effective immediately in case there's any emergency so that you don't have to go to court to have somebody deemed incapacitated. So that's the power of attorney. The advance directive is a document where you're naming an agent to make medical decisions for you in the event that you're not able to make your own medical decisions. And it also goes through, we recommend typically that people use the state form that's provided by the Vermont Ethics Network, just because it's the form that's most familiar to physicians and hospitals around the state. But that form, in addition to allowing you to name an agent, allows you to list certain preferences about what kind of medical treatment you'd like to receive. And it also lets you go into some detail about funeral arrangements that you might want to have. And then, as I mentioned, if you have really strong feelings about not wanting to be resuscitated or about receiving certain procedures, you can be in touch with your physician to do a do not resuscitate DNR form or a COLST form, which is clinician orders for life-sustaining treatment form, and that's filled out by your doctor and lists certain procedures and details about what you do and do not want to receive. So,
Perfect.
Yeah.
Thank you. At this point, I think we can, I don't have any other specific questions lined up, but we'd love to open it up to all of you. If you have a specific question you'd like to ask that hasn't been typed into the chat yet, please feel free to do that. Oh, there's a good one about lots of professionals mentioned, tax advisor, attorney, trustee, accountant, estate planner. Who does what and what are the overlaps? Who leads? Who should I find first?
Well, the estate planner can be, you can have one person do everything except perhaps the tax return. I mean, you might have a lawyer that does your tax return too, but theoretically, the attorney that does your estate plan would do your will and your bill of sale and your power of attorney and your advance directive. They can help. You can do your advance directive. You can get that form right online and do that yourself and register it with the state. But you don't need to have a bunch of different lawyers to do different aspects of your estate planning. You can have one lawyer do that and then your tax accountant. Would you agree with that, Livia and Jeanne?
Yeah, that's right. And then, oh, sorry,
go ahead, Livia.
I was just going to add, I think I definitely agree with that. I would also add that, if you aren't confident investing on your own, having a financial advisor who can do the investment piece would be kind of an additional job.
Yeah.
So, yeah.
Forgot about that. The money.
The money management part.
Yeah.
Sorry for cutting you off, Jeanne.
Oh, it's fine. I think the last thing is for sure you need your accountant every year because you have to file your individual income tax returns. Right. But there might be moments in your life where you're working with 3 advisors at once. And most commonly for estate planning, that would be a lawyer and an accountant and a wealth manager or a trust administrator, because you're making this estate plan. If there's any tax planning, you want to make sure your accountant agrees with the tax planning and how it would be reported. And then your wealth manager will have be able to assist with both things, titling assets and trust, and also making sure that any tax planning meets your cash flow needs. So for example, if people want to make gifts to charity or to otherwise, they have to make sure they keep enough money to live. and your accountants and your wealth manager can help you make that decision. So sometimes you have them all on the clock at once, but most of the time you don't. You just see your accountant every year. Plus also your dentist twice a year.
Here's a question. Are there any assets you might want to keep outside of a revocable trust?
Yeah, so there are certain assets that you would not typically title in trust. One that comes to mind right away is retirement accounts. So those typically pass by beneficiary designation. So you would list a primary beneficiary and a contingent beneficiary. And it's typically more tax efficient to have retirement accounts pass to individuals if that is appropriate, based on the individual's age and everything else, rather than routing those accounts through the trust. So.
And then what do you guys think about Ladybird deeds? As opposed to putting something in the trust having, and I don't know if you agree with them or not, but we do have some clients that rather than put their real estate in the trust, they will do something that we call a Ladybird deed, which basically says I reserve a life interest in this property to myself, but when I die, it goes to my kids. And during my lifetime, I reserve the right to sell it if I want to. So the kids can't force me to keep it. I can sell it if I want to, but if I don't, it goes automatically to them. That might not be in your trust.
So we use Ladybird deeds for those clients who are concerned that they will spend down all their assets and wind up on Medicaid. And the Ladybird deed is a way to ensure that the house will remain as an inheritance for kids. It doesn't always work for a couple of reasons. The first is that oftentimes if you do spend all your assets and you have to go into a nursing home, your children either can't afford to maintain your home, or they want to sell the property because they want to use those assets to keep you in a better location. But we do it in those circumstances. And I'll note that you can do a Ladybird deed so that it goes to a trust on death. So you can have your trust be the recipient on your death.
If you're going to do that, Jeanne, let me just ask Jeanne, because I'm educating myself here. Why wouldn't you just put it in the trust to begin with?
Because so I'm not an expert on Ladybird deeds, but I think that you have to reserve the life estate to yourself. So you can't put a piece of property into a revocable trust and also reserve a life estate to yourself.
Okay, that makes sense. That makes sense. Okay.
And somebody asked exactly what a Ladybird deed is, so I'll just answer quickly. A Ladybird deed is a special kind of deed that's allowed by legislative grace. It's also known as an enhanced life estate deed or just a Medicaid deed, but it's not the same as a quitclaim deed or a warranty deed. Those are deeds that actually transfer full interest in property to another person or entity.
This is a great question. If you file your will with a court in one state and then you move to another state, you have to refile it in the new state.
You don't have to refile it. You just have to make sure somebody knows where it is. I mean, you get everyday people on the probate listserv saying, trying to find a will for Joe Blow. So if you move, it's kind of a good idea to fetch your will out of the probate court where you're living and move it to where you now live. But you can leave it there as long as someone knows where to find it.
Okay, thank you. Does anyone else have anything pressing that they need an answer to, or a topic that we haven't covered that you'd be interested in hearing more about? Wow, you guys were complete and thorough this morning. Thank you.
We didn't have each other to feed off, so we wasted less time. I like wasting more time.
All right.
Charitable remainder.
Oh, there we go. Charitable remainder trusts.
Jeanne and Livia.
Okay, charitable remainder trusts are a kind of nifty way to give to charity. And this is a special kind of trust that's governed by a provision of the Internal Revenue Code, and it allows you to put money in trust and retain an annuity to yourself for the rest of your life. So you could give $1 million to Krista and say, Krista, man, give me 5% of this every year for the rest of my life. And then when I die, you can have what's left over. So it's a nice way to make a charitable donation, but also retain cash flow to yourself and manage sort of your lifestyle until you reach the end. I'm sure Krista likes them.
Well, and the thing is, you can name more than one charitable organization as the beneficiary. It'd be awesome if it were just BLT, but it's a tool that people frequently use to keep a flow of income during their lifetime. And then when they're sure they don't need the money any longer upon passing, it all goes to the organizations that they intend.
They get a tax deduction now for the value of that.
Right. There are sort of two ways. You can either, if you have a money manager that you want to manage the assets while you're alive, then a charitable remainder trust is a good way to go. A really simple way is a charitable gift annuity, which you would just make an irrevocable gift to the land trust, and then we manage the money in our own system and pay you a check every year or quarterly, however that works, and you get a charitable deduction up front and a lifetime stream of income until you die. So that's a great way to invest in the land trust future and in the legacy that you want to leave, but still have a stream of income. And we often see people take a portion of what they might have used in a bond portfolio for generating income, but it's a win-win because it also gives to charity. So that's one solution. There was a question that I'll just announce to everyone. They asked whether the land trust considers gifts of property other than gifts of pure land, whether we would accept a house and 5 acres. And those sorts of gifts, when we consider gifts of property, there are a couple of outcomes. If it's straight land and it has a really strong conservation outcome, for instance, it's adjacent to other conserved land, or it may be really beneficial as a park or in addition to a municipality, then we will be kind of the pass-through entity and focus on the conservation outcome without much of a financial benefit. But gifts like a house and 5 acres could be very beneficial to the Vermont Land Trust. And we've had situations where, in fact, the house that is our main office in Montpelier was a gift to the organization. We would then sell the gift and use the net proceeds to further conservation work around the state. So yes, please be in touch. This has been a real treat. I have to say, COVID has been very, very difficult in so many ways. And if any of you have been touched by it via your close, immediate friends or family, I'm sorry to hear that. I think we have a ways to go, but there have been some silver linings. And one of the silver linings is that we had 75 people sign up for our presentation today. And when we were doing them in person, as much as I loved my road trips with these women in a car, it's like, it's just so much fun. But the highest number of people we got in person was 25. So now we get to reach a whole bunch more people, which feels fantastic. And we get to see your faces and know that the information we're sharing with you, hopefully you will also pass on to other people. So there's good, solid, educated expertise floating through our communities and helping sustain them and build them and make them stronger. So we all have a better world.
Krista, are you giving them, or would you give them our contacts? Is that part of anything? So that if somebody has a question that they specifically want to ask one of us later, they can follow up.
I sure will. We will do a follow-up email after this with a link to the video, and we'll have your contact information with that so you can reach any of these 3 women directly. So if beyond that, unless anyone has any question, I would just like to thank you very much for attending. Share this video far and wide with, maybe this can be the way you start your conversation with your family. So thanks so much. Thank you, Caitlin. Thanks all my VLT people, and thank you all for attending. I really appreciate it. Have a wonderful.
Thank you, Krista. Thank you, everybody.
Thank you, everyone.
Have an excellent day.
Okay. See ya.
Thanks,
Take care.
everyone.
Bye-bye. Thank you.
Bye-bye.